Like many other states, North Carolina does not prohibit a third party from providing financial support to a party that has already initiated legal action or decided to do so. Indeed, in a recent case, a North Carolina court specifically held that a litigation funding agreement was enforceable. A litigation funder will get into trouble in North Carolina only if it does something to instigate a suit. The leading case on litigation financing arose from a typical agreement for an advance to a personal injury plaintiff. A funder advanced $3,000 to a plaintiff, which was to be used to cover the plaintiff's personal expenses during the pendency of the litigation. The plaintiff eventually obtained a significant settlement, but refused to repay the funder. The plaintiff raised several arguments for why the agreement should be deemed unenforceable. First, she argued that the litigation financing agreement constituted an illegal gambling contract, but the North Carolina Court of Appeals rejected this argument, pointing out that a litigation financing contract cannot be characterized as a gambling contract because it lacks two essential qualities of an agreement for a wager: that the wager involves a contingent event in which neither party has an interest, and that the agreement involves a zero-sum result in which one party wins while its counterparty loses. The plaintiff also argued that the litigation funding agreement was void as against North Carolina's usury law. But the Court of Appeals rejected this point as well, noting that the agreement did not create a loan because it did not create an absolute obligation to repay. Finally, the Court of Appeals rejected the argument that the agreement could not be enforced because it was champertus. As the court explained, our courts have held for at least a century that an outsider's involvement in a lawsuit does not constitute champerty or maintenance merely because the outsider provides financial assistance to a litigant and shares in the recovery. Rather, a contract or agreement will not be held within the condemnation of the principals unless the interference is clearly officious and for the purpose of stirring up strife and continuing litigation. If you need help with litigation funding, call or email me today.